Just give everybody a few more minutes before we get started. Hey, Eric, have you seen any issues with tenants? Commercial side? Eric,
What was your question?
have you seen any issues with tenants on the commercial side yet?
As far as collecting rent?
Yeah, that and people now trying to downsize.
Yeah. Luckily, our tenants have, all but one have applied for PPP loans.
Okay,
And I guess they have enough, they've applied for enough money to make it through for a couple of months. So
okay,
we'll see
good.
if this thing continues.
Yeah, we're seeing a trend across the country where, based on all the experts, are saying that a lot of companies, that have people working from home are like, I don't know if we're going to bring them back. It's working out just fine for them.
Yeah, well, ours is more of a service industry, with
Right.
hair cutting and nail salons and restaurants and dentists.
Got a few more people jumping in here. Just give me a second. I mute you. I've muted you all. I think if you push down your space bar, to talk, you can. If I'm not mistaken. Somebody try it. Let's figure it out. If you hold down your space bar, you should be able to talk.
Yep, it works.
Does work.
Okay.
Seems to work.
Hi, eating breakfast.
Where are you at, Trey?
In my office.
Nice background you got there.
Where is it? Yeah, thanks. I took a picture the other day. I put all kinds. I'm liking the Zoom thing a lot.
Yeah, I
it's
like it
kind of
too.
exciting.
Hey, Carol Cooper.
I'm eating breakfast over to the left.
We can't even see your face. You're just a shadow.
All right. Give them one more minute, Suzanne, then we'll go.
Yeah, that sounds good. I sent an email out again.
Good. Well, we've got this recorded, so at least we'll have it available for people. I got everybody on mute. You just hit your space bar to unmute yourself, or if you want to talk, you can also raise your hand. You can also use the chat box if you want to. Several different ways that you guys can talk to us and let us know what you're doing. All right, I'm just going to go ahead and get started so we don't keep you here all the whole time. So the reason we call this meeting is during the QB meeting yesterday, a couple issues, we now know that there's a couple issues with some different brokerage firms requiring buyers to use this, specifically RE/MAX at this point, to use a special form for showing where there's a questionnaire. I want to just start by saying 100% this, no one is to sign this form and to forward that form to Suzanne or myself immediately so we can take a look at it. And we can give you some language as to how to answer it. Supposedly, they're not letting you show the property, but from what I'm gathering, I think most people are being able to show the property without answering the questions. The concern is that the violation of privacy rules, and that's why we really want to just stick to the COVID-19 forms that Neymar has given us. And again, there's no qualifying brokers allowed to tell you or us as qualifying brokers which forms we have to have our people sign. We do not have to, we're under no requirement to sign other people's documents or have our clients sign other people's documents. That is what the COVID-19 documents are for. We're going to go through them this morning, but that's one of the first things we wanted to talk about today. Has anybody run into that form yet or something, the broker's generated document? Again, you can press your space bar down to talk.
I
Yes.
did, Michael. I had it for a showing that for a buyer, and we didn't fill it out. I just called the other broker and told them that the buyer said they weren't hadn't been near anyone that they've known of to be sick, but that we weren't filling out the form.
Okay, perfect. That's exactly how we want to handle it. Is just, and if and my concern is I don't know. My biggest concern is I don't know if this is being passed along to the sellers and how they could this could potentially limit the number of people who see their home. So hopefully it works out just as it worked out for Debbie, where we don't have to worry about it at all. With that said, let's talk a little bit about showings. And before we get into the COVID-19 document, Susanna and I wanted to just touch base with you on a couple of factors. We do have this ethical obligation we have to our customers and clients. And so I would have a, I don't know, for lack of a better term, a COVID-19 kit in your car. I would definitely have a mask, have some type of cleaning solutions, and anything else that you may have to help you with your showings in your car. All of us, when we are showing property, our ethical obligation is to wear our masks. I'm just telling you this based on a number of different conversations that have occurred since the governor has set forth the fact that we should be wearing masks. Our ethical obligation is to make sure we do so. Remember, we're not wearing a mask to protect ourselves, we're wearing a mask to protect others. And we're just out of ethical, responsible, professional obligation to our sellers and buyers as well. We need to do a little bit better job of explaining the documents to our clients that we have. We now have 7 documents as it pertains to COVID-19. Suzanne, you want to add anything to that?
No, that covers it.
Okay. Anybody have any thoughts or concerns or have run into issues with this already? Okay. That was easy. All right, so let's take a look at these documents, these COVID-19 documents that we have. I'm sharing my screen with you, so let's just run through them real quick. Hopefully. All right, so the first one we've already gone over before. It's the coronavirus. This has to do with if we had to, because of coronavirus, we had to extend the closing times due to whatever reason, lender issues, can't get back. We could extend it for basically 10 days, but it also relieves everybody. If we have to extend it for up to 30 days, both parties can elect to terminate, and then we would fill out the termination agreement and the earnest money dispute form. However, with that said, initially we thought this should be applied to all transactions. I'm really concerned about that because we've been told that several buyers have tried to jump out of a transaction or postpone it just because of this document, not for any other reason. So if we do have somebody that's going to try to postpone the closing, we need to make sure that it's for a valid reason. Also, please remember that you need to communicate with your customers and clients that COVID-19 is not a reason to terminate it by itself, unless it affects your job or a number of other things. So, but COVID-19 is not a God effect. It is not force majeure. By definition, the state of New Mexico, this does not fall within the force majeure guidelines. So I just wanted you to be aware of that. Is there any questions on force majeure or any concerns? Anybody tried to go do that already? Okay. All right. Next, the next document that we'd like to go over with you is the hold harmless agreement. This one you may want to consider when speaking to. This is designed to protect the brokerages, hold harmless. This is like a blanket hold harmless agreement, just to make sure that people understand that they can't come after us if something happens during this crisis. And I don't even consider it a crisis. It's just a change in reality. And so what we have to understand is that this is creating precedents, as Eric and I were just discussing. While it doesn't affect his commercial tenants, a lot of businesses have decided, we're looking at this nationwide, are coming to a conclusion that they have all these people working from home. Why do we have to have so much commercial square footage? So this is a new reality for us. So we just have to make sure that we try to hold ourselves harmless. We also have to make sure that we understand that lenders are taking a little bit longer time than they normally would. Lenders are also verifying that the people that they're lending money to their jobs are not affected by this in some way, and that could potentially cause a problem. We're also seeing lenders are moving away from, for the time being, any specialty loans. It's like jumbos. They're not investing very much in jumbos right now, which is a concern for our higher end properties. They're not investing in in items that don't fit within the Fannie Mae Freddie Mac box. So anything that we consider non-prime or subprime, those are right now are a little bit of a challenge.
Are they also requiring higher credit scores?
In some cases, yes, I've seen that they're not going deep. What I've read online is that they're not going as deep, and we probably should have had to talk to a mortgage broker on this. But what we've seen is they're not going as deep on credit scores as they normally would. So that's another challenge. So any questions on that or concerns? Okay. The next document is the 1502. This is the addendum that we'll have to the listing agreement. To the listing agreement itself. Basically, my recommendation is that we do apply this until we are out of this, and just basically to let people know that we will not do any live open houses during this period. A matter of fact, virtual open houses we're finding more traffic with virtual open houses. And if you have need any information on how to do a virtual open house, I'll be more than happy to do a one-on-one with you and kind of give you some guidance. But if you go online, they have all kinds of information on virtual open houses. Basically, what a lot of people are doing is they're marketing the open houses like they would any other open house through social media, and even doing flyers for the neighborhood that the property's in, and then holding the open house in like a Zoom meeting presentation where they can actually get people to register to come into it. When it comes to live open houses, something that you guys need to be, something that a lot of people are unaware of is when you have a live open house, one of the things you have to make sure is that you know everybody that comes in and out of that house for insurance purposes. So when registering people that come into the open house on live open houses, it has nothing to do with leads, even though that's what we want from it. It has to do with homeowners insurances, and we have to make sure we know who goes in and out of that property. But this, going back to this document, there is a right to see showings if they want to. Take reasonable precautions, like maybe do virtual showings, which is really easy with Matterport. Suzanne just had a 3D Casa do a complete package, including the Matterport video and square footage drawings and all that for $125. Is that correct, Suzanne?
Yeah, and it was like a 1,200 square foot house.
So that's pretty good. That's a pretty good deal right there. For those that aren't doing Matterport video, I'd definitely look into it. And it's this is the new reality for us. These are things we should have been doing anyway before COVID-19, but this is a new reality, and this is going to be the new norm for our customers and clients, or for our clients or sellers. We're finding nationwide. Redfin said their video, their virtual showings online has risen 500% since COVID started. Zillow said somewhere around 400%, which pisses me off because Zillow, Zillow was on the brink just a second ago, and now they're building us on our backs again. So we're giving them all our stuff, which great news about that, though, is they're trying to give us control of that information back again, and we'll talk about that at some other future point. There is a proposal. NAR's got a proposal right now to allow us to have more control of our data instead of giving it to everybody else. But this is a hold harmless for the seller, and explaining everything when it comes to listing a property, how you will perform under that. Any questions on this document here under our listings, or any concerns?
No, but going back to the open houses, there's a tab in MLS when you're under your listing for open houses that you can put a virtual open house in there.
That's awesome.
And there's also training on GAR's website how to do them as well.
Good, that's awesome. So yeah, and it's exciting because the virtual open houses are just really getting more attention. So that's kind of awesome.
But as far as virtual open houses go, we personally still have to go to the house and do the open house.
Correct, yes. Thank you. And
I
then,
noticed that you can now search in MLS by video and only show properties with video.
wow.
So I realized that, and so now I'm making videos for everything because you don't want to get left out or get missed out of that search because you don't have a video.
That's a great point. And I'm going to tell you, videos, Mark Zuckerberg told us years ago that by 2020, videos would be it. And here we are. You could have never predicted COVID-19, but this is something we should have been doing anyway. But here we are. We are now where videos is 100% part of our practice. We cannot get around it any longer. So thank you for bringing that up.
Yeah.
So the property, this is a property management one, so I don't need to really go over this. But just know that if you are, well, we don't have any property managers on the call today. And it has nothing, you can't use that document if you're managing your own property. So we won't worry about that. We won't worry about the tenant one either. But the 1505, Dan.
Hey, Michael, sorry to interrupt you, but I just had a thought. And I ask a quick question about property management.
Yes,
do occupancy agreements throw us into the category of property managers?
No, that's a great question, Dan, and no, they do not. I always talk about the occupancy agreements. First and foremost, we should avoid them like the plague.
Right.
There's a lot of liability and risk for both parties, not to us so much, But here's the thing, in accordance with paragraph 11 of the occupancy agreement, as long as we do not handle the money, we are not acting as a property manager. We can't touch the money at all when it comes to that. If we were to touch the money, we would have to have a property management agreement in place, and we are not property managers. And the other thing we have to remember is that occupancy cannot be more than 30 days for either the buyer or seller. But if a seller were to stay in after closing, we have a huge problem, especially if you hit that 30-day mark, in the fact that since the seller is not buying the house, the seller could potentially be covered under the Uniform Owner Residential Relationship Act because it could potentially go over 30 days. The buyer is not covered under the UORA because they are purchasing the home and they're considered an occupant. Sellers considered an occupant too, but the buyers are definitely just an occupant. One other thing when it comes to sellers, if you do an occupancy where the seller is going to stay in after, please check with the lender before you allow that to happen. The buyer's lender will probably not allow it for many different reasons, because of the 60-day rule with Fannie, FHA, and VA, and a couple other issues too. So check with the lender before you do that. So thanks for bringing that up, Dan. That's very important. This is a hold harmless for remote viewing and sight unseen documents. This should have been around a long time ago. It's only because of COVID-19 that we have it, but this document should be used not just for this period, but from here on out. Because if we have to understand that people can buy houses sight unseen, and so this is a document that we would have the buyers sign. So a party acknowledges the risk inherent in purchasing or renting property by sight unseen. It talks all about the risks, and so the buyer or tenant needs to sign this document. So anytime we do remote viewings or purchases where they do not see the property live, they should sign this document so that they understand the risk. In our Air Force communities, they sign these documents all the time. And so, I mean, they buy houses sight unseen all the time. So this is a really good document. Any questions on this one? It's going to be the new norm, ladies and gentlemen, where we're going to have people buying houses sight unseen. And so hopefully I will stop getting those phone calls by people going, oh my God, these people didn't even see the house and they made an offer. That's just unacceptable. I will not allow my sellers. Remember, you're not an agent to your sellers either. You've got to give them the ability to understand, hey, these people are providing this offer sight unseen, but you have to acknowledge the offer. The 1506 is a hold harmless for sellers and buyers. This is an interesting one in the fact that this form is used by sellers and potential or actual buyers will be viewing or inspecting the property in person. Potential buyers are those not yet under contract. So this is in place of that document that the other brokerage has. This acknowledgement says, hey, listen, you potentially could be, this could be a potential issue to you, and that they hold us harmless in that. So another document, I don't see this being used very often, but you know what, if you have people that ask questions about COVID-19 and the risks, then this is probably a document we'd want them to sign. Any questions on that one?
Was that the 1507?
That's, yeah, the 1506.
Okay.
The 1506. Oh, no, yeah, 1506.
Okay.
And then finally, the last one is the 1507. This is just an information sheet. So you know, it's one of those things maybe you provide. Again, I don't know that we want to make any of these so much so that we have to require it. It's just good information sheets. And remember, you can't force another party to sign it. You can't even force your own customers and clients to sign it. It would be good to acknowledge it though. And so just to keep our liability at a very low or minimum risk. While we're sitting here looking at documents, one of the other things that I would definitely encourage you guys to do is we set this as policy, but I don't think anybody realizes this. When we list property, we made a policy for our firm that we would go over the purchase agreement with the seller before they even an offer was made on their property. The reason we want to do this is because we want to make sure the seller is aware of the vehicle that an offer would come to them, and talk to them about what each paragraph means, or just give them an idea. You do not have to go verbatim. You do not interpret it, which you're not allowed to do. You're just allowed to say what it says. So let the buyer sellers know that, as you can see in this specific paragraph, if the buyer feels that they cannot move forward, the buyer has the opportunity to terminate, and they get their earnest money back. Do you say they can, or do you say that they will? I just heard this the other day where a buyer's broker told a buyer they could get out of the contract for any reason whatsoever. You and I know this, but you and I are not attorneys. When anybody wants to terminate, we need to make sure that they seek legal advice. We would recommend that they seek legal advice before they do. Whether they do or not is not on us, but make sure you put that conversation in writing that you told them that they should seek legal advice. But please, please go over the documents that we have, that you have people sign, help them understand what it means. Just go through each paragraph, and it takes you about 20 minutes. But you know what? This is the time to shine, ladies and gentlemen. This is the time to show our value in the fact that we know what that document says. So please do that. Please be aware this is something that's come up lately. You also need to be aware that we have many different forms available to you that you may have to consider disclosing to people. For instance, we have all these information sheets, right? One of them is the mold disclosure, the information sheets. So we have this whole list of documents here, and I'm not going to go through all of them, but let's talk about the mold disclosure for just as an example. The 2309, right? When you having your buyer interview and you start asking them what kind of concerns do they have, if they say anything about respiratory issues or anything like that, this thing better go with it. Matter of fact, I'm considering just saying this should probably go with all files, because what are the first three words? Mold is everywhere. The reason why this is important, so that you understand why I'm making a big deal about this, is several brokers have found themselves in a little bit of liability because we have these documents. It's good that we have these documents to disclose information. It's bad that we have these documents to disclose information. Because we have them, if a client had any concerns or expressed any concerns about an issue that we have an information sheet on, we should probably give them the information sheet. The reason why is because if we don't, for instance, the reason I'm bringing the mold one up is there is a situation where a buyer had children that had respiratory issues that the buyer broker was aware of. The house did indeed have mold, and the respiratory issues called into question. Then they started looking for, of course, the buyer starts looking for somebody to blame. We became an easy target because we have this document and it was not provided to the buyer. So we become an easy target at that point. So anytime we have documents that anytime we have documents that you are concerned of, that could be concerning to your client, please just provide it to them and say, hey, just so you know, this is information on what you need. Oh, you have solar panels? Here's an information on solar panels. These are your rights and obligations. Oh, you have a septic system? Here is a information sheet on septic systems to let you know what your rights and obligations are. Lead-based paint. If the house was built prior to 1978, we have information sheets on that. And we just don't have enough time to get into lead-based paint today, but I promise you lead-based paint is a huge issue. We could probably have a class on lead-based paint all by itself, and I probably will very soon. Very scary situation for us when it comes to liability. But when it comes to documents, please do yourself a favor. Please, you remember our obligation in accordance with our code of ethics is to bring clarity to the transaction by going over the documents that we have. So please do that. Please go over documents. What questions do we have on that or concerns? Okay. Suzanne, would you like to add anything to that?
Good.
Okay. All right. So the other thing when it comes to documents and bringing clarity to transaction, this is your time to shine, ladies and gentlemen. Let's do a better job with documents. Let's get them into me, get them into Suzanne as soon as reasonably possible so we can review them and make sure everything's good to go, especially when it comes to the lead-based paint disclosure. I'm just going to give you some simple advice before we ever have a class, just to keep you up. If there is ever a time that your buyers are looking at buying a piece of property that was built before 1978, or you're getting ready to list a property that's built before 1978, one of the questions that has to be asked, were there any renovations done to this property since 2010? If there were, we have the RRP disclosure that must be provided. Can I force a seller to fill it out? Absolutely not. But if they're not willing to fill it out, we need to disclose that they're not willing to fill it out. You and I can be held liable if we do not disclose or document the fact that they're not willing to fill that document out. Anytime a house was built prior to 1978, if you, for our investors or people that are dealing with investors, remember if they buy a house built before 1978, you've got to let them know that the RRP is a real issue and that they probably would want to get the house tested for lead to make sure that they follow through with their obligations to RRP, renovation, repair, and painting. If we do not, we can find ourselves liable. If you allow an investor to buy a piece of property and then all of a sudden they decide they don't get it tested and they do remodel it, they do remodel the property outside the lead-based paint requirements, this could be a potential issue for them, and then we have to disclose in MLS that it was not done within the EPA guidelines. Just as a thought. Any comments or questions on that?
If they didn't follow the guidelines and it was an investor, and could they cover themselves after the fact by doing a test, a lead-based paint test?
That's a great question. I think if they can show that there was no lead in the house, that would be okay. The challenge is that they did the work prior to not their knowledge, and that could be an issue. But as long as they can prove that the house had no lead, that's fine. And you know, a true EPA test is what you need. You need one like Scott Herman, who formerly was part of ABQ House Detectives. He is a certified EPA lead-based paint inspector. And a true lead-based paint test costs about $500 because they have to use an extra red machine, and they have to use an extra red machine. They have to test every wall inside and out, every door inside and out, every door frame, every window frame inside and out. So it takes quite a bit. And Carol has her hand up. So Carol, go ahead.
So my question, you mentioned a minute ago about we can't make them sign anything or do anything, but we have to disclose it. What's the document that I would use if I had a house that was built in 1975 and I know that the owners did work on the house and they didn't do, I don't know what they did.
Right.
What's the document and what do I do with it? Is it something I post on MLS?
Well, you have if they won't sign the document, so they have to sign the lead-based paint disclosure form. That has to be signed. That must be signed by both parties. But when it comes to the RRP disclosure, which is the, I can't remember the number. Let me see here. The 5112A, if they're not willing to sign it, which I don't know why they wouldn't be, because there is no risk in signing it. It's just, all they're doing is disclosing their knowledge of it. But if they do not sign it, I would make sure that we get an email from them saying that they're not willing to sign it. And then in MLS, just put the fact that renovations have been done since 1978. Put it in the LOSO remarks, and any further questions come to
Wouldn't
you.
you just use supplemental broker duties?
You could do that too, yeah, that they won't, yeah, that renovations have been completed, but since 1970, since 2010, seller has no knowledge or will not disclose knowledge of whatever was done. That's a
Yeah.
little concerning, and what I would definitely do is express your concerns to them on that by not filling out that document. That could leave them in some serious liability. Debbie?
I filled it out. I did one where they had done renovations already, and I put it in the 2100 and had the seller sign it that they had made repairs to the home and had not done lead-based paint testing. Is that okay?
Yeah, that's
And I
perfect.
uploaded that 2100 with my documents in MLS.
Perfect. As long as we have something in writing saying we did this, and that's what the 51, what's good about the 5112A. It does not, as long as the seller acknowledges what work was done, that's what I think what's really cool about it. And this is how I had expressed to Mr. and Mrs. Seller, since you've done renovations since 2010, I want you to be aware that did you do the work or did somebody else do the work? If it's their primary residence and they did the work, there is no liability on their part. If they hired a contractor and the contractor did not do the work per regulations, the contractor can find themselves in some hot water. The homeowner, no. Because the homeowner doesn't know anything about this RRP program. So I would, to Carol's point, just document it. If they won't sign a 5112, just kind of tell them that this is a way of relieving them of some liability more than it won't increase their liability for sure. It can only decrease their liability. Hope that helps. Suzanne, you have anything to add to that? Okay. All right, so one other thing that I truly appreciate about the Forms Committee that they've helped us out is the buyer broker agreement. This is written much nicer now, and I am considering making this probably our policy that we use it from now on, because it really, they've changed the items that I had really concerns about, like paragraph 6. I've always been concerned about paragraph 6, and they corrected paragraph 6. So let's talk just a few things. When it comes to terms, remember, if you have a buyer that needs to be in a house in 60 days, and the lender's going to take 45 days to close the transaction, you only have 15 days to find that person, get that person under contract. So I wouldn't make the terms any longer than you have to. Number one, that shows a sense of urgency. Number two, that shows that you are committed to your buyer's timeline. The problem is with most people, they use this term as long as they want to. They use it like a listing agreement. This is not a listing agreement. This is a buyer broker agreement. You need to show that your buyer that, hey, I know we got to get this done this certain period of time, and so we got to get it in. And remember, this in accordance, just like the listing agreement, this paragraph shows that this agreement does extend through the life of the purchase agreement. And then paragraph 6 is a lot different, broker compensation event of purchase. This is where it explains that we are going to try to be compensated by the seller, so that you guys understand in our code of ethics, Article 1, Standard of Practice 113, states that you and I must disclose how and by whom we are being paid. So we have to disclose to the buyer that the seller is paying us and this is how much they're doing. Any bonuses the seller's offer us has to be disclosed. So we have to make sure everything is disclosed to the buyer. And so you would always check mark A. A would always be check marked because this states that you're going to make every attempt to get paid by the listing broker. If you feel that you want to, you are worthy of, and Suzanne and I can make this decision because we're the qualifying brokers. If we want to be paid more than what is offered in compensation in MLS, then we would check mark here. Ladies and gentlemen, do me a favor. Please do not decide which properties you're going to be shown based on compensation in MLS. It is a slippery slope and one that is currently, we have plenty of lawsuits across the country on. Remember, the Department of Justice in October of last year sequestered all of CoreLogic's data, and there is proof that we show properties with less compensation less often. So let's be careful and make sure we just show properties based on our clients' needs, not compensation. But this gives you the ability to get more compensation from the buyer if you so choose. And then C allows everybody to understand if I'm going to show a property that's not on the market or is for sale by owner or just not on the market, then this says that if I cannot be compensated by the seller, then this is what I expect out of you. So this document's much better. It's exciting that they finally changed this. It even has compensation earned and due paragraph. And then number 9, value estimates found on various websites. I love that they put this in here so that everybody's aware that the value estimates are completely inaccurate. So this is a good document, and I highly recommend that we start using it, and I probably will start making it a policy for my team. Any questions on the buyer broker agreement? Because it is a lot better than it used to be. Okay. Any other document you want to go over, Suzanne?
Probably just to go over broker's duties and how we need to disclose them
Okay, awesome.
early in the document that you created.
Yeah, appreciate it. So if we look at the broker duties, I'm just going to pull up the broker duties one more time here. If we look at these broker duties, this document, this page is overwhelming. And honestly, it is our job to disclose these prior to generating and presenting anything that could be an express written agreement. My problem with that is, and this has not happened yet, my problem with the express written agreement thing is that sometimes we text people and we make an agreement to do something. That's an express written agreement. So I'm really concerned. This has not been called on the carpet yet, but I'm really concerned. And so I will tell you this, because most people didn't use the buyer broker agreement up until now, the first time most buyers saw this document was right before they signed a purchase agreement. And usually we just fly right past it. Hell, here's my broker duties, initial here, sign here. This document is overwhelming. This looks like a contract. It's written by an attorney. It sounds like it's written by an attorney. It looks like it's written by an attorney. So people are very frightened by this document. And if you talk about your broker duties verbatim, you can get to number 3 before they all start to gloss over and tell you to stop talking. Let me just read it myself, right? But it's very overwhelming. So I would really consider coming up with a different option and do it much earlier. So what I came up with is, I came up with some slides, and I know a lot of you guys have seen these slides before. So let me pull those up real quick.
I've sent everyone on my team, and I can resend the broker duty slides.
Okay.
And you guys should be presenting this in an email after you've discussed broker's duties and have them acknowledge that they've received it prior to writing a contract.
So to Suzanne's point, what I would like to see happen is when you're going to a listing appointment, it may be a good idea to give them a call before you even get there and say, hey, if you don't mind, in the email I just sent you, just express some of the documents that I hope you have available. I also included a copy of my PowerPoint presentation where I go over my professional obligations. If you don't mind, I'd just like to take a couple minutes and go over those professional obligations so you understand how I will do my very best to protect you throughout the process of you selling your home and as our relationship progresses. If you're working with a buyer, same thing, prior to them giving you any information. Very important. And that's what you tell them. You tell them, I'm providing you, I would like to provide you this information So my professional obligations, which the state calls broker duties. So you have a very good understanding of how I'm going to protect you in every possible way throughout our our relationship. And then very simply, these are my words. You can change them if you want to make them your words. But what I took is I took honesty, reasonable care, ethical, and professional conduct, and I broke all the broker duties down and made it simpler to a knowledge, right? Honesty, full disclosure, adverse material facts. So that you guys understand what the legal definition of material fact is. Loosely stated, is a fact, if known by the decision maker, could potentially change their mind. And then, so disclose. If you feel you have to disclose, before you call me and ask me if you need to disclose, okay? Just gonna tell you, if you're asking the question, you probably should disclose. All right, full disclosure of material interest, whether it's business, personal, or familiar in nature, I would definitely do that. You remember price, terms, and motivation are 100% confidential, and make sure that cannot be used. That goes great with you. Remember that we can keep confidential any other information as long as it's put in writing and it doesn't violate law. When it comes to reasonable care, remember that we got to make sure we understand how often people want to be contacted, what's the best way to contact them. We also want to make sure they understand we have a firm grasp of real estate laws to protect all their interests. We will put everything in writing. Every conversation we have will be in writing to include this conversation we're having right now. Acknowledge that you're not an attorney, that you will assist somebody with their needs and wants by filling in the blanks on an attorney vetted document. But if they have any concerns about that document, please, they should seek legal advice. We're not accountants, we're not home inspectors or structural engineers. We will not measure homes. Before I go any further, just so you guys understand, paragraph 27 in the purchase agreement for residential property says, this is our disclaimer, it's our get out of jail free card. Please, for the love of all that's holy, do not measure homes anymore, because you can find yourself in some liable situations. So we do not investigate things that are outside our scope. Again, just make sure to tell them to put people in front of them. They give us the keys of the kingdom, or they entrust money in our care, we must treat it as if it's our own. And lastly, ethical and professional conduct. Make sure you disclose that we're not an agent state of Mexico, that we're a transaction broker. Now, I can explain this to you at some future point, but people truly don't understand the definition of transaction broker. Any documents that you read, if you look at the statute, the law and rules, it does not say anything about representation, and that is true, 100% fact. As transaction brokers, we do not truly have a representation agreement with a buyer or seller. We are actually facilitating the transaction for them, right? We have a legal obligation and sometimes a contractual obligation. Rarely do we have a fiduciary obligation, which would create that type of representation. However, I do want to caution you that people don't understand that. So that's why we talk about the fact that we're representing them. But legally, there is no representation. And therefore, we're not acting as an agent. And so all we can do is make recommendations to our customers and clients, make a decision. Ultimately, it is up to them to decide. Just like the purchase agreement speaks about the fact that it's up to them to stay on time and on target. It's not our obligation. However, under reasonable care, the real estate commission will come after you if you do not try to protect them and make sure that they stay on time and on target. And that's what our job is. Make sure you understand that you cannot answer for your customers and clients. So if a seller intends to reject an offer, we put in the listing agreement under their obligations, we put in the listing agreement that if they intend to reject an offer, they need to put it in writing that they're going to reject the offer, and then we provide that statement to the other side. We cannot let it die in time. We have got to get written evidence that they rejected the offer. That way, that is going to be the proof that the seller actually was presented the offer, And this is the way it's always been, but now it's become an issue. And so we have to make sure that anytime we have a buyer or seller that's not going to, a buyer or seller that's going to reject an offer, whether it's an offer or counter offer, whatever, that statement has to come from them. And so that would be our proof that we actually reviewed the offer with them. We are not agents. We cannot answer for them. We can only make recommendations. So please stick to that philosophy.
And going along with that, please stop using the word agent. We are brokers.
Yeah.
So if we say we're agents, we're implying agency, I would think.
Yeah, and there's no legal implied agency, but yes, to Suzanne's point, anybody that comes from anywhere, they think we're an agent. And, you know, all it would take is a judge on the bench to have one bad day to think, you know, you're acting as an agent, I think I'm going to make you an agent. And so the only agency relationships that exist in the state of New Mexico by default are property managers to their landlords, and you, an associate broker, to your qualifying broker. You guys as associate brokers are agents to us, the qualifying broker, whoever your qualifying broker may be, whether it be me or Suzanne. And so our job is to protect you. We owe you fiduciary obligations just as you owe us fiduciary obligations. You owe us obedience, loyalty, disclosure, confidentiality, accountability, reasonable care, reasonable skill. We owe you PIRC. We must perform as if we're a qualifying broker. We must indemnify you. We must reimburse you if any expenses on our behalf, and we must compensate you for your efforts. So we owe you just as you owe us. But when it comes to buyers and sellers, by default, we are not agents, and we need to stop acting as if we are. Any questions on that? By the way, I know Abigail's on the meeting today. You should congratulate Abigail. She did a really good job of going over agency, but they tried to become a pre-licensed instructor, but they tried to deny her based on the fact that they had the EAC. There was only one member of that EAC that has the right to judge her, and that was David Steele. So if you ever get a chance, congratulate her on getting through that process. She's in good company because several of us had a hard time getting through the EAC when it comes to agency. But I just wanted to give a shout out to Abigail on that. But any questions on this? You guys will get a copy of this so you can have it. Now you present this to them early. Maybe you don't have them sign the listing agreement or buyer broker agreement that day. And then, so what you do is at the end of the day, you go, Mr. and Mrs. Buyer, thank you so much for meeting with me today. I look forward to assisting you in finding a home. And I just wanted to reiterate what we talked about, the decisions we made. Also, I did go over my professional obligations, which the state calls broker duties. If you don't mind, if you can just respond to me and just verify that you have no questions about those professional obligations. And when they respond, you now have written response. You have written acknowledgement that you went over your professional obligation or broker duties. And let me tell you something, in a hearing, that'll hold up much more than just the initials and signatures. All right, any questions on that? All right. So you guys are all so quiet. What's going on? Any other topics or concerns, you guys? Dan, go ahead.
We're hungry.
That's funny.
Mike, can you go over the recommendations form for repairs and all that stuff?
Oh, yeah. Let me bring that up. So first off, let's make sure that we do not make recommendations ever or referrals ever again. I know that sounds weird, but I'll show you guys what I mean here in just a second. We should only stick to making recommendations for vendors, not, we should not be referring anybody whatsoever. I know that sounds weird. What's the difference? There is a legal difference. And the reason why we want to do is we don't want to get into what's called negligent referrals. So this document I'll send out today too. Basically, this is a document, you can put it in an email form, whatever it may be. I put a home inspector here, but let's say we're talking about plumbers. Anybody we recommend to somebody that requires a license, we have to make sure any of our recommendations that we make, that person holds a license, insurance, and bonding as required by law. So let's say we put 5 plumbers in here. I'd probably put a minimum of 5 at all possible, but then just say below, please find a list of licensed plumbers our customers, clients have used in the past. There's our recommendation that no matter who you choose, that you verify the vendor, hold the license certificate and license insurance is bonded by law. Be aware there are many other choices options out there. It is our policy that we do not refer or choose any vendors. Please do your own due diligence. Let us know who you choose to hire, and we will assist in making sure the work performed is done scheduled properly. The reason why we want to do this is we want to try to relieve us of some of the liability. We want to make sure now, we've talked to Ashley Strauss Martin about recommendations. If you do make recommendations such as this, let's say the day we make the recommendation, that plumber has a license, insurance, and bonding as provided. But tomorrow, they go ahead and drop their insurance or something like that. When we made the recommendation, they had it. And this is why we're laying it off on them, just like in the listing agreement and the purchase agreement. It is up to them to do their own due diligence. But we provide, anybody we provide must have a license. When it comes to home inspectors, so you guys know, they were supposed to be start licensing them at the beginning of the year. That did not happen. They had their first meeting in February. They still don't have a statute, and they probably will not start licensing home inspectors till the first of the year for the residential people. On the commercial side, most of the commercial inspectors are all contractors, so we don't have to worry about them too much. What other questions you guys got? Go ahead. Sorry.
So basically you can be using this document and recreating it for every field that you need. If it's title officers, if it's, for anything, you can keep reusing this document for everything. And to my group of associates, I sent this out within the last 10 days, this exact document.
Cool. What else? Any concerns? All right then. Well, if there's no concerns or questions, I think that's a lot of information right there. I personally am going to make some changes. We have to, because of the change, the uniqueness of the change of the environment we're in now, we're going to make some changes to the whole process. And I hope the change in the process is very helpful. One of the things, Suzanne, should we go over NetSuite today or no?
It hasn't changed for them. It just looks a little different.
So remember, comp sheets are done through, it's called
NetSuite.
Yeah, it's called
NetSuite.
Connect now, yeah, NetSuite.
Yeah, it's still NetSuite though. So you guys just go in and fill out your comp sheets the same way. The form, it's just formatted a little differently. And eventually you'll see some other tabs on there in which you can see how much income you have made, how much money you have made for any documents that you might ever need for the future over the year.
All right, anything else? All right, so we're recording this, so if anybody wants to share the recording with somebody else, we'll let you know, and then we'll send it out. I'll put it up on YouTube, and then we'll send the link out to everybody, anybody who wants to be seeing it. So thank you, everybody. One more thing, sorry. We're looking into creating I'm looking into creating a referral brokerage, because we can foresee some people going to inactive status because of the fact that we have, there are a lot of expenses. And so some people may go inactive. Rather than go inactive, if you can go to the like a referral brokerage, you can still go out there and do what you're supposed to, create and cultivate relationships, and then pass it along to somebody and get a referral fee on it. So that's kind of cool. So just so you know that that's available. All right, ladies and gentlemen, you have a wonderful day. Our hour is up. Bye.
Thanks, guys.
Thank you.
Thank you.
Hey there.
Hey there.
Hey, Abigail.
Sorry. I have 2 kids
Thank you
on
so much.
our technology, so I couldn't get on like right away.
Cool. Well, once we get this recorded link done, it takes about an hour for it to download. I'll get it to you.
Awesome. Thank you so much. Let me know if you need anything. Thank you for the shout out.
Okay, no problem. Trey's got some of the funniest backgrounds.
It's fun. I love Zoom. I could live this way. I could just stay in my little hole and just chat people up, and I can get to every meeting on time.
Yeah, this is my favorite way to teach now.
I love it.
Yeah.
And we should just live this way from now on.
Right, cool.
It's especially since my wife works in the ICU and I never work